Namaste, friends, and welcome to our Saturday edition of Legal Words of Wisdom, Nyay Gyan Ganga, on our Virat Hindustan Sangam social media channels. As you know, we have been conducting these Legal Words of Wisdom, and today is episode 19. We have with us, as usual, Dr. Subramanian Swamy and Dr. Venkat Iyer to speak on a new topic. As every Saturday, we discuss one important aspects of the law to educate the common man on the importance of law and how to tackle or deal with a situation where they may be involved. Today, we will be discussing a very recent and aspect of the law, that is the right to information, whether it is a boon or a bane. Almost everybody agrees that information is power, and in a democracy, people need a lot of information about the government and about public institutions to make informed choices, for example, at elections. Is that expectation fulfilled in India? What are the laws in this area? How reasonable are those laws? How well do they work in practice? Is the administration or government too secretive? If so, what can be done to improve the situation? Is there any need for a change in public attitudes to those seeking and obtaining information? These are some of the issues that will be discussed in today's episode on the right of information. So, with these opening remarks, uh, Dr. Swamy and Dr. Venkat Iyer, as you all know, has been conducting this series of episodes for Virat Hindustan Sangam. Will be speaking at length, and as you know, Dr. Venkat Iyer is based in UK, and he is an academician, mediator, lawyer. He has earlier worked in the Indian courts, and now he is based in UK. So, with these opening remarks, it is over to Dr. Swamy for his opening remarks. But I wish to thank my co-host Ramesh Swamy and our technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Tejas, Rakesh Gadgi, and Swaminathan for their support to put this every Saturday program together. We will be, as usual, on Sunday at 8 p.m. on our Sunday regular Words of Wisdom Gyan Ganga. And tomorrow we'll be having an interesting topic for discussion. So, with this remarks and thanking viewers across the globe for their patronage, it's over to Dr. Swamy.
Thank you, Jagdish. The right to information was a concept which the Americans were pioneers. We were not very far behind. After the Watergate, I think the American feeling for more accurate information and government being compelled to give it grew in loud in voice, and it was done. And in 1977, in the Janata Party manifesto, we put in that if we will put, when we come to power, we shall bring the right to information. But we were so busy quarreling with each other that we, in 2.5 years, we did not move in the matter. In 1984, when the Congress was in power and totally against the right to information, naturally, I brought in a private member's bill, and it is called the Right to Freedom of Information Bill. And it was listed for hearing, and but very soon after, Mrs. Gandhi declared, Mrs. Gandhi terminated the session in early August. So my private member's bill lapsed with that. Thereafter, many people went to court, and the courts then began taking very active interest. And finally, although the NDA government, Mr. Vajpayee, also tried to bring in a Right to Information Act in 2002, but they, beyond an act, they didn't get very far. And then, of course, in 2004, Vajpayee's government lost power, and when the Congress came, they were again not at all in favor of it. But the Supreme Court directed the government to bring in a right to information bill because they said it's part of Article 19 bracket 1 bracket A and also even of Article 21 in an oblique way. So therefore, it was enacted in 2005, and then over some years, it began to expand. And then you ran into this question that how much, what are the boundaries of right to information when you have a right under Article 21 to privacy? And so a High Court judge called Puttaswamy, K.S. Puttaswamy, Puttaswamy, he filed a writ petition, and that writ petition was taken before a 9-judge bench, so that there is no controversy about which bench had decided what in the past. And they considered the matter on August 24th, 2017. They said the right to information is an intrinsic right, the right of life, and under Article 21. So subsequently, the RTI Act had a section called 8 bracket 1 bracket J, which said that the fundamental right to privacy will prevail, however, subject to public interest. So because all fundamental rights are anyway subject to reasonable restrictions. So this, and then 1994 earlier, we had Jeevan Reddy's right to privacy question, and that kind of was connected actually to defamation because the Nakiran magazine had come with a petition, and I had also the same petition, but Miss Jayalalitha, who had filed 100 defamation cases against me on one blow, withdrew all the cases for fear that it will all be dismissed. So therefore, Jeevan Reddy took the documents that I had introduced before him, along with the other, the Chief Justice, and then he passed a very, very important judgment on not only privacy, but what about defamation when it is a defamation of a public person. So we have today that situation. I think Venkat is the right person to guide us through the Right to Information Act and what the scope is, what's the limitations, so on. And what I think is basically there's a constant struggle between the right to information and the right to information and the right to privacy. And how that conflict or contradiction can be resolved is a great art in itself. And therefore, over to Venkat to lead us on the path to what it means in terms of human power. You must remember that information is considered power now. And in democracy, you cannot elect unless you have a complete authenticated information. There are lots of lies which are told during the campaign. They are told lies before on educational qualification, on the amount of wealth, and so on. And all these can be accessed subject to certain restrictions if it can be shown that there is a massive public interest involved. So with those preliminary remarks, over to Venkat.
Thank you, Swamy. Today's topic is, at least superficially, one which should not be controversial. Who doesn't want access to information? And after all, as both Jagdish and Swamy have pointed out, information is power, and it helps people in many different ways. But the issue of right to information is not quite as clear-cut as all that, as I hope to be able to illustrate in the course of this discussion. For a start, where does this right come from? it is not mentioned specifically in the Constitution. So it'll have to be derived from some other existing right. In the Indian case, it has been seen as part of the right to freedom of speech and expression guaranteed under Article 19(1)(a) of the Constitution, as Swamy has just mentioned. Also, of course, there is frequent reference to Article 21 of the Constitution. The rationale for a right to information is, in simple terms, that everyone in a democracy has at least an expectation to know about the activities of public authorities, although that expectation cannot be given effect to in absolute or unconditional terms. There are good reasons why people can be denied information about public authorities. Alternatively, certain limitations can be put on what people can expect by way of information about such authorities. You can see straight away, therefore, why the right to information is not a completely straightforward issue. When you dig deeper, you'll find other challenges with this concept, which I shall try to at least outline in the course of this talk. Before I do so, I want to say something by way of background when it comes to information and how it is treated in India. As in many other fields, there is a huge contradiction at play. On the one hand, a massive culture of secrecy pervades the activities of public authorities in India. Most of the time, if you ask a government functionary at any level for information about anything, including quite harmless, innocuous things, the instinctive answer you will get is no. It is almost as if government servants are programmed to deny any request for information. On the other hand, however, in purely practical as opposed to legal terms, India is a country where it is possible to get the most confidential information about almost anything, as long as you know how to negotiate your way through the opaque system. To give you a hypothetical but by no means fanciful example, you may be able to get hold of the personal mobile phone number of the Prime Minister if you know the right tactics, but not the date of a forthcoming government announcement. This is part of a wider problem with India, which once led the British economist Joan Robinson to say famously that the frustrating thing about India is that whatever you can say rightly about the country, the opposite is also true. That background is important to understand how the system works. Another preliminary point I want to make is that the right to information cannot be understood without an appreciation of its links to other concepts like official secrets, data protection, and individual privacy, to which Swamy has also made reference. Unless all these concepts are harmonized, any legal regime on the right to information will be wobbly at best and unworkable at worst. What then is the law currently in force? It is called the Right to Information Act of 2005, and it is usually referred to by most Indians as RTI, which is not to be confused with another similar acronym, RTE, which is about the right to education. I understand that there are also similar laws passed by certain state legislatures, presumably to deal with matters falling within the competence of respective state governments. I'll try to explain the essential features of the 2005 Act, but I cannot claim to be exhaustive in my description, mainly for lack of time. The first thing to note about this law is that it only covers public authorities, that is, the government and all bodies which are funded, controlled, or substantially funded by the government. This is a very important point because I sometimes come across people who naively believe that you can ask for information from or about purely private entities, for example, large private corporations. There is a good reason why that is not allowed, and it has to do with the fact that what private entities deserve to be given is a degree of autonomy, because their activities are not financed by the taxpayer for the most part, And there are also other mechanisms for accountability. For example, questioning by shareholders under company law, or the fixing of liability under contract law. But there can be some situations where the distinction may not be clear cut, in which case it will be up to the courts to rule on whether a private body should be required to provide information under the RTI. An obvious example would be where there's a public private partnership in the building of, say, roads, or metro rail systems, or even the running of prisons. Now, what is the type of information covered by the law? The Act allows for inspection and provision of documents and records, including information held in discs, tapes, cassettes, or other electronic devices. It also allows for the taking of notes or extracts, or the provision of certified copies of documents or records, and certified samples of material, as long as all this is held by or under the control of a public authority. Crucially, the law casts an obligation on all public authorities to ensure that their records are duly classified and indexed in an accessible manner. It also requires public authorities to publish a whole lot of information concerning their activities, the records they hold, even a directory of their officials, etc., and to update such information frequently. They also need to make this information accessible to the public. I presume that the commonest and easiest way of doing this would be by putting up such information on the authorities' website. Though I have to say that many of the public sector websites in India are so user unfriendly and dense that I wonder if what they put up there is of any practical value. There are, of course, some particular challenges in India when it comes to disseminating information. First, the low level of literacy, which means that not everyone will be able to understand information, even if it is provided to them in a readable form. Secondly, the language barrier. With only a tiny minority proficient in English, and with the population being divided on linguistic lines, even those who are literate may not be able to read large chunks of the information that is disseminated. Interestingly, the Act recommends that maximum use must be made of electronic means of dissemination, which raises another challenge: the uneven spread of internet access around the country. This means that the involvement of middlemen is inevitable, and therein lurks yet another problem, namely of gullible people being fleeced by the middleman. Now, all applications for information have to be made either conventionally in writing or through electronic means to a central or state public information officer, PIO, with sufficient clarity about the information being sought. If the applicant needs help in making the application, the office is obliged to offer the necessary assistance. I understand that there is a nominal fee of 10 rupees to be paid per application. One of the commendable aspects of the Act is that it expressly states that there is no need for the applicant to give reasons for his application. In spite of this provision, I understand that public authorities, and shockingly even the courts, have sometimes shown scant regard for it. For example, a judge of the Delhi High Court called Pratibha Singh was reported to have insisted in a case heard by her less than a month ago that whenever information is sought under the RTI Act, the applicant's interest in the information in question should be disclosed, apparently to establish his or her bona fides. She is, of course, clearly wrong, and that part of her order deserves to be set aside urgently, ideally with strong strictures. A similar order passed by a division bench in the Madras High Court in 2014 led to protests from lawyers and activists, but at least the two judges involved in that case had the grace to revoke the order themselves within about a week. If an applicant makes a mistake about the public authority who holds the information he wants, there is a duty cast on the authority to transfer the application to the correct authority within 5 days and to inform the applicant accordingly. All applications need to be disposed of within 30 days. And if an application concerns the life or liberty of a person, it should be disposed of within 48 hours. When no reply is given within those time frames, the applicant will have to assume that his request has been rejected. If the public authority requires the applicant to pay further fees, it will inform the applicant of this fact and provide him with details of how the additional amount has been calculated. The additional fees will have to be reasonable, and it should be waived in relation to applicants who are below the poverty line. Provision has been made for an appeal against the imposition of unreasonable additional fees. Where an application is rejected, the authority has to give reasons for the rejection, along with information about the appeal that can be filed. Then comes a crucial part of the Act which exempts certain types of information from disclosure. This includes information that would prejudicially affect the sovereignty and integrity of India, the security of the state, relations with foreign powers, or which would cause incitement to an offense or contempt of court or a breach of parliamentary privilege. Also, information that would be commercially sensitive or would constitute a trade secret or information that is received in confidence from a foreign government. Also exempted is any information that relates to the investigation of a crime. Not surprisingly, cabinet papers will also be beyond disclosure, as would information which would lead to an unwarranted intrusion into another person's privacy, a point to which Swamy made brief reference earlier. I've only summarized the exemptions and not given you an exhaustive list. But there's a welcome proviso to the exemptions, and it is that in certain circumstances, if there is overwhelming public interest, then even exempt information can be disclosed. This is very valuable, but it relies on good judgment and sound common sense on the part of those who operate the system. A particularly welcome aspect of this proviso is that even information that would be covered by the Official Secrets Act can be revealed if there is overwhelming public interest. Hearteningly, information that relates to occurrences, events, or matters that are 20 years old or older can be revealed anyway, although when the 20-year period should start has been left to some extent to the discretion of the central government. I will return to the Official Secrets Act later on in this talk. Another good aspect of the RTI Act is that even where some information cannot be disclosed, if other information from the same document can be revealed and it can be severed from the rest of the document, it shall be offered to the applicant along with reasons for doing so. Where the information requested is about a third party, then the public authority has a duty to inform the third party and seek its views before deciding on whether the information should be revealed. There are strict timeframes for this entire process. Now, how is the RTI regime enforced? Essentially through an information commission, which is a tribunal. There is, first of all, a Central Information Commission, which is meant to be an independent body. Its members are selected by the Prime Minister, the leader of the opposition, and another minister nominated by the Prime Minister. The commissioners are to be chosen from eminent people with expertise in such areas as the law, journalism, social service, technology, management, etc. No one holding an office of profit or carrying on a business or profession will be eligible for appointment. As a rule of thumb, the chief commissioner and other commissioners will serve only one term and will step down when they reach the age of 65. They will all be paid salaries which were originally pegged at the same level as that of members of the election commission, but these were depegged in a controversial move in October of 2019, which also reduced their terms to 3 years from the original 5. Many commentators fear that the independence of the Commission has, through these amendments, been weakened. Can information commissioners be removed from office? The answer is yes, but only by the President after he has sought the opinion of the Supreme Court and only on grounds of proved misbehavior or incapacity. A commissioner can be removed without the Supreme Court's intervention in certain circumstances. For example, where he's declared a bankrupt or is convicted of an offense which involves moral turpitude, or if he engages in paid employment while in office. And there are similar provisions made for state information commissioners. Now, what do these commissions do? They entertain complaints from anyone who has been prevented from submitting a request for information under the Act, or whose request has been refused, or whose application has not been dealt with within the time limits prescribed in the law. Complaints can also be made if a public authority asks for an unreasonable fee to accede to an information request, or provides incomplete, misleading, or inaccurate information. The commissions can undertake investigations, and they have the power to summon witnesses, to take evidence on affidavits, to requisition documents, etc. No public authority can deny access to any record when it is sought by the Commission. What about appeals? Appeals to the Commission should be filed within 30 days of the decision of a public information officer, although this period can be extended in exceptional circumstances. Such appeals can also be filed by third parties who are aggrieved by a decision of a public information officer. It is possible for a further appeal to be filed in the various commissions, and this will have to be done within 90 days. There is a duty on the commissions to dispose of appeals within 30 days, although this period can be extended to 45 days for reasons to be recorded in writing. The commissions have been given wide-ranging powers of enforcement. They can compel public authorities to reveal any information that's been withheld or refused. They can they can issue orders to appoint PIOs to publish certain categories of information, to make changes to the way information is handled, even to provide training to a department's officials in dealing with RTI requests. They can also order compensation to be paid to an RTI applicant, and crucially, they can levy a penalty on a PIO of 250 rupees per day of delay, obstruction, or refusal of information, subject to a maximum of 25,000 rupees. In addition, of course, to ordering disciplinary action where appropriate. A couple of other things before I finish. No suit or other proceedings can be launched outside the framework of the Act, and the Act will prevail where there is any inconsistency between itself and the Official Secrets Act, which is a good thing. Very importantly, and in the view of some activists controversially, there is a near blanket ban on the application of the RTI Act to any intelligence or security organizations listed in a schedule. And these include, apart from the IB, RAW, the Enforcement Directorate, etc., various specialist police forces, the Narcotics Control Bureau, and a couple of special branch units. Although an exception is made for information concerning corruption or violation of human rights. Where human rights violations are concerned, the information will only be released after it is approved by the Central Information Commission. There is a duty cast on the information commissions to submit annual reports, which are required to be laid before Parliament or the concerned state legislature, as the case may be. The Act also requires central and state governments, subject to availability of resources, to carry out public education programs and also staff training on the law relating to RTI. They need to publish guides explaining how the Act can be used by the public. Now, how good is the regime established under the RTI Act? I think most fair-minded people will say that it is reasonably good. There's always a tension between disclosure of official information and the need to keep some such information secret. This is a tension which exists even in the most liberal societies, and it cannot be avoided. Only an extremely naive person would argue that all information in the possession of the government should be disclosed. Especially in the present era of terrorism and other genuine threats to the life and liberty of citizens, to make such a demand will not only be foolish but also dangerous. There is another aspect to the subject. Even within democracies, governments must be allowed some secrecy about its deliberations. There have to be free and frank exchanges, not only between ministers, but also between ministers and civil servants, for example, about the pros and cons of policies that are being considered by the government. If such exchanges are thwarted by an excessively tough and rigid RTI law, many of the discussions will be carried on outside official forums and frameworks. Anyone who has served in government will testify to this reality, and I suspect Swamy might have something to say on this matter. As an aside, I might say something about equivalent legislation in the UK, which was introduced with great fanfare by the Labour government of Tony Blair in 2000. A few years later, after he ceased to be Prime Minister, Blair publicly admitted that enacting this legislation, which is called Freedom of Information Act in the UK, was the worst thing that his government had done because it had unintended adverse consequences. He called himself naive, foolish, and an idiot for bringing in this law. And those were his exact words. They are there prominently in his autobiography, which was published in 2010. Now, how has RTI law worked in India? I can only go by media reports, and these in turn rely heavily on research presented by NGOs. It is possible that many of the NGOs are biased, but it is equally possible that at least the statistics that they show are accurate. Apparently, the number of RTI applications filed has increased dramatically over the years, with a figure of 40 to 60 lakhs being cited for each year. Unfortunately, the capacity to deal with this volume of requests doesn't seem to exist, so that a massive backlog has accumulated. More worryingly, it was reported that in only 45% or so of the applications was meaningful information provided. Prominent examples of denial included information about the demonetization, about willful loan defaulters, and about the PM CARES relief fund. Also, apparently, many posts of information commissioners at both central and state levels were not filled when they fell vacant. No less disturbingly, many RTI activists were apparently attacked around the country, with some 80 odd people being killed. On the other hand, Transparency International, the anti corruption crusading NGO, was reported to have said that out of the 33 odd million RTI requests filed in the past 15 or so years, only 9% of decisions were taken in second appeal, which means that the vast majority of applicants were apparently satisfied with the results they got. Interestingly, it appears that, unlike in countries like the UK, not many journalists use the RTI law in India. But the law has been open season for all manner of inquisitive citizens who seem to have a lot of free time to themselves. A particular target of RTI requests appears to be the current Prime Minister. One activist from the Congress party was reported to have filed a request asking the Railway Board if there was any record, registration number, or official pass issued to Mr. Modi, allowing him to sell tea on trains at stations. Another request from a lawyer wanted to know about Mr. Modi's father's tea stall in a railway station in Gujarat. I've also read about certain other requests concerning the Prime Minister, like the number and type of gas cylinders used in the kitchen of his official home, the name of the company which manufactured the teleprompter which is used by the PM, whether the PM had ever read the Constitution of India, a copy of the payslip of the PM, whether the PM's personal secretary or principal secretary had ever taken people working in the PMO on a picnic, a list of all bank accounts maintained by the PMO and the transactions in those accounts, and so on and so forth. These are just the tip of a monumental iceberg, and even a cursory trawl through the internet will indicate the extent to which the RTI law has been taken to heart by crackpots, publicity seekers, and busybodies. Only slightly more seriously, but no less indicative of the mindset of many RTI applicants, there was a case reported just this week in which a husband sought the income tax returns of his own wife through an RTI application. Mercifully, the Information Commission in Delhi refused that request and sent the applicant packing with a flea in his ear. This case shows the potential for misuse that an RTI law can be subjected to. And unless a culture grows in society at large in which such adventurism is firmly discouraged, the misuse will continue. I mentioned the Official Secrets Act earlier, and I want to spend the last couple of minutes offering some thoughts on that law. It was enacted in 1923, and it contains some sweeping provisions if it is read literally. Though targeted mainly against espionage, it has sometimes been used against journalists. The main culprit is a clause, section 5, which makes it an offense for anyone to possess, use, communicate, retain, or fail to take reasonable care of information or materials which has been obtained in breach of the Act, or which have been given to him in certain circumstances, and which, of course, is likely to affect the sovereignty and integrity of India, the security of state, friendly relations with foreign states, etc. I'm, of course, paraphrasing. The section itself is quite long and complexly worded. The scope for abuse of this provision is most evident when it comes to whistleblowers or journalists who wish to expose wrongdoing. So, for example, there was a case in 2011 in which a reporter for midday newspaper in Bombay noticed some sophisticated weapons lying unguarded under a leaking roof in the city's main railway station, and he published a story about them. Those weapons had been bought by the government after the 2008 terror attacks, but had been stored carelessly. The journalist was charged with an offense under the Official Secrets Act. Fortunately for him, the Bombay High Court came to his rescue and ruled that what he had done was entirely innocuous. Similarly, there were threats made to journalists working for the Hindu newspaper in 2019 after they had published leaked documents about the Rafale deal, which the government found embarrassing. I haven't been able to find out if charges were actually brought against the Hindu, but the dangers still remain. A good defense to any such prosecution would be publication in the public interest. The Act itself does not explicitly state this as a defense, but the courts have recognized it from time to time. Another example of the misuse of the Official Secrets Act is the indiscriminate labeling by the government of various buildings as prohibited places and the imposition of sweeping bans on photography. Nothing could be more absurd than preventing people from taking pictures in front of, say, commercial airports, especially in a country where it's quite common for ordinary people to want to be photographed with relatives or friends who are about to leave the country and whom they have come to see off at the airport. Officially, this is illegal. The absurdity of this mindless prohibition becomes even more stark when you realize that we live in an age where satellites are able to take pictures even of the number plates of cars from miles above in the sky, which means that a hostile foreign country which wants to know about an airport in India does not have to depend on pictures taken by individuals using amateur cameras. In substance, what I'm trying to say is that there needs to be a radical change in mindsets when it comes to dealing with public information. And that change seems a long way away. I think I'll stop here for the moment. Thank you.
Okay. Thank you very much. Very, very clear presentation. And,
Dr. Swamy, can you, sorry to bother you, Doctor, can you come a little bit closer to the computer so that your audio is a little bit low?
Okay. Is that better?
Yes, sir.
Well, first of all, I congratulate Venkat for taking a very complicated subject in terms of its ramifications and putting it so nicely and simply. I would like to add 2.5 points. One is a short point that he talked about how the people are getting harassed by people wanting information. I also want to tell him that there was a period about a few years ago when a substantial number, maybe 7 to 11, between 7 and 11, of RTI activists who were murdered because they were able to expose gangsters in, say, toll booths and things like that. So it's a very it's a developing subject and it needs to be done. There are two areas where I feel that the general public doesn't know. Most people don't know. And that I intend to now mention. One is that there is the cricket control is in the hands of a body called BCCI, Board of Cricket Control of India, something like that. Now that's headquartered in Bombay. It's a private body, and enormous amount of money goes through it, and especially with this craze for cricket in India. And so the issue became whether I could get information about how much money they're getting, how they're spending, and what is the criteria and so on. So since it's a private body, everybody said that there's no question. And you also said that private bodies, it has to be a public authority that you're asking about. But I must say, I took a chance because of there was this huge attack by mafia against the Chennai Super Kings. They wanted to eliminate it because somehow one got the impression that people in Bombay were not happy with that Chennai was stealing a march in the IPL over Bombay. So the Chennai Super Kings was targeted. So, and the BCCI was in the forefront, being the apex body. So I went to court, and in the court, the process, how could you file a case when you're not a cricketer and you're not part of any of the regional organizations? How can you file a case against the BCCI? And lo and behold, the Supreme Court was impressed with the facts I brought on record. And some of them are really, even today, have not been published. of emails exchanged between various important people. You know that today BCCI has got all kinds of politicians and their sons and all in key positions. And it's in cross. So what happened is the Supreme Court and the Chief Justice at that time, was very sharp mind, and he said, asked the question from the advocates, and there were 8, 9 senior most advocates against me that time, and they asked the advocates, we want to ask you. You say this is a private body engaged in a government in a sport which the people come. There's no government in this, but don't you need police? They said yes. What about the traffic management? He said yes, that has to be handed to the police. What about the maintenance of order within the stadium? So a series of questions the Chief Justice asked, and then they gave an order that the BCCI may be a completely private body, but it utilizes government support for its activities. Even the ground that is given for the match for the pitch is government grant by a government grant. So therefore, they are subject to judicial review if somebody comes with an appropriate PIL. That's how a private body was brought into. The second one was Jethmalani was expelled from the BJP. It was shocking because Jethmalani was the real mastermind who ensured that the Congress was not able to prosecute Mr. Narendra Modi and Amit Shah in the Gujarat riot matter. And a man who had performed the service should be so unceremoniously expelled because of the hatred of Mr. Jaitley for Mr. Jethmalani. So Jethmalani then filed a case. And in fact, the same argument was used that cricket, like cricket, a political party is allotted bungalows for its party president. So Amit Shah was living in Akbar Road. He was that time not an MLA, not an MP. And anyway, even if he was an MLA, he couldn't get it. He was not an MP. And then other facilities, police, so on. So it's the same thing was brought in. And Jethmalani then began to prosecute the BJP for its illegal, without giving him notice, nothing, a bland one-letter thing that you're expelled. He decided to prosecute them. And the matter naturally got traction because of this BCCI case. And then, lo and behold, Mr. Amit Shah and Bhupendra Yadav, one of the general secretaries, went to Jethmalani's house and said, now let's forget what happened. Your expulsion is being removed. So he said, no, I will not accept that. You have to apologize in writing. So they gave a letter in apology, which was not published, but a copy was given to me by Jethmalani, where both Amit Shah and Bhupendra Yadav in separate letters expressed a regret and apologized for taking this action of expelling from the party. So a political party which was considered a private thing and an arrangement of mutually now cannot remove anybody from the party without due process, because you can take them to court for it. And I think hardly anybody knows about this, and it's not been publicized. But the party constitution has now become an extremely important document. Now it's no more just a thing to show the election commission, but it is so like that. Now we are finding that the expansion is taking place of the power of RTI. Now, RTI can ask questions about BCCI. RTI can ask questions about a political party, and you have to show public interest. There was recently an RTI which wanted the accounts of political parties which were getting foreign funds. I think that had been stayed by some court order, and I think it doesn't proceed. But the question is that this kind of transparency, if intelligently used, RTI is a huge weapon in the hands of the people. This is what I want to comment in addition to what you said. What do you have? What's your reaction?
Yeah, I would agree with you, because this is exactly what the philosophy underlying freedom of information, or the right to information, has been. And it is good that the judiciary is looking at it not in a very technical, bureaucratic way, but more the spirit of the law. And you're absolutely right in terms of also the analogy with judicial review, because technically judicial review does not lie against private entities.
Yes.
But there have been occasions when the courts have gone behind the facade and tried to see if there is any element of public involvement, not necessarily direct government involvement, but something that gives the body a public character. And since we don't have too much time, I'll simply mention that in the UK, that process began with a case called DataFin, which involved an entity in the city regulating business, which was a purely private entity, but which was made amenable to judicial review. So yes, I mean, it's a very good development.
Yes. Well, I hope you will help us explore new avenues for expanding the RTI.
Absolutely. Yep.
Okay, Ramesh, it's yours.
Venkat, I have some observations or questions.
Yes.
One is, most of the RTI applicants at the threshold level face a new tactics employed or used by the officers. What they say is, suppose somebody asks for some document, they are told that these documents, you come and inspect these 500 files which are lying under the custody, and please select whatever you want. So if there is a specific, for example, somebody wants to have an occupation certificate of a particular building, the building may have 50 documents or 100 documents or 100 files. So they will put this information to the applicant, say, come and inspect this file, to just mislead them on these issues. That is one type of tactics used, so that they are discouraged. So I just want to know whether what they can definitely go in appeal, but it's a cumbersome procedure. How does other parts of the world, or if you have any idea, deal with this type of subject?
Actually, you don't even need to go to other parts of the world, because the RTI Act in India itself is very specific about these situations. You cannot make applicants go round and round, or give them so much information that they are unable to actually get what they want. And the logical solution, if the public information officer persists in such behavior, is for the information commissioner immediately to pull them up, and to even pass an order fining the person, the public information officer who did this. But of course, that brings us to the problematic area of enforcement. And if what I hear is true, namely that there is a huge backlog of cases before the information commissions, then quite clearly the purpose is defeated to some extent, because the applicant will have to wait, I don't know, for 2 years, 3 years before his appeal before the commission comes up. So other than that, I can't think of any silver bullet to deal with this problem. But I'm absolutely sure that the law itself is totally against any such tactic.
May I add something to this? You see, when I was embarking on the Aircel Maxis case. You know, the Aircel Maxis case was that there was a industrialist in Malaysia, a Tamil native, but I mean born and brought up there. He decided to enter the telecom market in India, and he went and bought up a company which was originally owned by 100% by Indian Tamil, and then the Mr. Dayanidhi Maran was the minister. He twisted his arm, and so he sold it to at a not a very good price, but good enough price to this person from Malaysia. And then after that, Mr. Chidambaram, who was a finance minister, he cooked up a arrangement by which, because the maximum that a shareholding can be there in an Indian company is 74%. So in order, and the buyer, who has obviously bribed a lot of people in the Congress party too, he said, no, I must have 100%. Otherwise, I'm not interested in getting out. So what they did is brought a dummy, and they were so callous and so so cocksure that nobody would investigate them. They created a total, got hold of a novice lady and gave her the 26%. And the money, ironically or stupidly or without thinking, was that she produced for that 26% for the shares, to buy off 26% shares of the private company Aircel as a joint venture, was given in by check by the Malaysian 74% partner himself. So directly 74% and indirectly 26%, he got the 100%. Now, unfortunately, this had to be cleared. First, it had to be vetted by bureaucrats, and then in a body called Foreign Investment Promotion Board. And then that would say, yes, this can be considered. It meets the minimum requirements. So then it goes to the finance minister and he says, I approve. So it went to Mr. Chidambaram and he said approve. Now what happened is I filed a RTI. And the finance ministry, at that time still Chidambaram was the finance minister when I filed it. The officials said that the files are so many, if you are ready to come to the ministry, we will arrange a room for you and you can see it. Now, I'm not just a layman. I've been a professor and reading documents. I read 1,000 pages a day without difficulty. So I went to the ministry and I got the whole scandal fully documented, photostated, and took it and filed in court. And that's how Mr. Chidambaram had to go to jail for it, along with his son. So I think this kind of tactic can only work with ordinary people who are loners, and can't work with somebody who works with a team, like I'm working here and on this show also, where the team is doing all the work. I'm just appearing and speaking. So I think the RTI, the officers will be making a great mistake if they are not discriminatory about who they can use that tactic and who they can't use that tactic. So they'll just give it as an anecdote.
Yep.
Another interesting issue is, for example, I am from the city of Mumbai and Venkat has been associated with Mumbai. A few months ago or a year ago, there was a big hue and cry against RTI activists that they were collecting a lot of information against crooked builders, and the builder uh, mafia connection. Surprisingly, there was a big fire which broke out perhaps in the Kamla Mill compound, and when media agencies or some studios also got burnt, and a lot of people died in a restaurant which was illegally or semi-legally running there. So after that, the high officials of the corporation and other agencies started making open statements in the media that RTI activists should be discouraged, and started spreading the word that they have vested interest to collect their information. No doubt the information sought should be given, but why this trying to malign the RTI applicant? It happens even with Dr. Swamy. What is Dr. Swamy's vested interest to get the information and all that? Because all crooks always find that if any information, especially government agencies or they people whom they want to protect, if this likely to be exposed, then they always attribute motive. Why did you expose the 2G scam, or why did you expose Hegde's NRI plots in BDA Bangalore example? I'm just making a remark. This is very topical subject which happened in Mumbai, and the commissioner perhaps was trying to say that RTI activists should be discouraged. In fact, I don't know how you could even make a statement. You should have been hauled up for disobedience, because he is also covered under the RTI Act. This was an observation, Venkat, if you have any comment on this.
Well, I suppose the hardy applicants will simply ignore such comments. But if you wanted to actually, if you had again, I come back to this point, which I know may be irritating to some people. If you had a functioning legal system, some of those observations, depending on how they framed it, could actually be defamatory, and you could actually, go to court and, in the case of India, even file a criminal complaint of defamation against such people if it becomes persistent. But having said that, there is one other side to this which I'll just mention in passing, and that is, it is not unheard of for certain blackmailers to threaten legitimate people with RTI requests and say, look, I'll get this and that and the other, and I will nail you to the mast. That sort of a thing. Basically a delay tactic. For example, if somebody was doing something constructive, some housing project, the easiest way to stall it is by saying, I've got dirt on you, which will be exposed via the RTI route. So it is possible for RTI to be misused, but that is no reason to scrap the law or to dilute it.
So there is one question here. It just says, does the RTI Act not allow why the action was not taken by the authority concerned?
I didn't quite understand why.
Let's say, for example, some action was supposed to be taken by an officer, and they did not take an action, and they refused to say, can we go seek information as to why that officer did not take an action? Let's say there was a flood relief, or there was an emergency. Let's say even the hypothetical case of Kamla Mill compound. Let's say the fire department or some department did not, or let's say the buildings department did not do a good inspection. So that's the kind of a question.
Absolutely, because that would be public information that wouldn't be covered by the Official Secrets Act or exempt under any of the other clauses. So certainly, yes. But obviously, you can't expect the RTI regime to punish the person who did not take action. So what you'll have to do is get the information, and on the basis of that, file a proper criminal complaint against the errant official.
Okay. Dr. Swamy, as a follow-up to your BCCI thing, so if any entity, if it's private, if it's got some government funding,
Yes.
is that subject to RTI?
Yes.
Only for the component that they've got, or they're pretty much open to anything?
No. Every action of his has it's open.
Because the reason I'm asking is,
give money. You can take up a government bungalow. You're open then.
yeah, because a lot of the educational institutions these days, they kind of go saying that they're a private entity, but they're getting funded.
No, if they're getting funded, then no, there's no escape.
Okay.
A technical answer, Ramesh, to your question is, the Act itself uses the phrase substantially funded. Now, what is substantial will be dependent entirely on the facts of each case. And I would agree with Swamy that a sensible judge will not be very nitpicking about the phrase substantial funding, and then he'll see how best the spirit of the act can be applied.
No, I think any sensible judge should say 1 rupee is substantial.
For example, political parties have exemption of income tax.
Okay, I was just about to come to the point. Good, go ahead.
So when they have such a big exemption of income tax, it is a big component. It is a public affair. See, if there is another organization, there is no exemption, but here there is an exemption of income tax. So that makes it all the more, liable for public scrutiny.
In other words, they are an indirect beneficiary of public funds.
Yes.
Taxpayers' funds. So that I, as a public, have a right to know how you are functioning.
The shocking part, I think, Venkat, you mentioned this in today's talk, was this PM Care Fund. I am still scratching. How did that? How can they even say that you don't have a right to information on that? Because you act, as a prime minister, you're a public person.
By the way, just to interrupt you, I have a right because they've cut my salary and taken it every month, 70,000 rupees they take away from me and put it in PM Care Funds. I have a right to file a RTI. They can't say no.
And that is an involuntary deduction.
No, it's not involuntary. It's a voluntary deduction, but I have a right to know how it's being spent.
Of course. Yeah.
But I have not done it yet.
And, but Dr. Swamy, you didn't opt in to contribute, right? It's just like some kind of a mandate.
They passed a general resolution in Parliament that we will agree to cut.
It's got a good cause. But you can't just say, because I'll take money from you, but I'll not tell you where I put it. That's crazy.
They've got away with it. Nobody's challenged it. And you got dummies in the opposition. What do you expect? Or blackmailable people.
Okay. Jagdish, you can do 10:40. Yeah.
Yeah. Friends, with this, we come to a end of another interesting episode on the what is popularly known as the RTI Act, or the Right of Information Act. I thank Dr. Subramanian Swamy and Dr. Venkat Iyer for their useful inputs on this show. And I thank our viewers across the globe for their questions and their interest they have shown in this series of programs. I thank my co-host Ramesh Swamy, and I also thank our technical team led by Ashish Shetty, Ishwar Iyer, Rakesh Gadgi, Tejas, and Vishal Mehta and Swaminathan for their useful inputs and cooperation for putting this program together. Tomorrow we will be back at 8 p.m. Sunday, 8 p.m. Indian Standard Time for another interesting Sunday episode of Words of Wisdom, Gyan Ganga. We hope to see you there at 8 p.m. So with this, thank you, Jai Hind and Dhanyavad.
Thank you.